Thank you so much, Wayne, and thank you also to Global Rights Compliance for partnering with Sweden on this project. There are basically three reasons why Sweden found that the project that you're carrying out, Wayne, through Global Rights Compliance is an important one. The first one is this, that Sweden is a small country which is not part of any military alliance. For us, international law needs to be the basis of international relations. This is a core national interest of Sweden, and for that reason, it's also important for Sweden that international law develops in a way which keeps pace with developments on the ground, with the way relations between states develop as well. And we believe that Ukraine is a case in point. What happened in Ukraine in 2014, both in Crimea and in the east of Ukraine, raised a number of questions for us about the nature of interstate conflict that we believe need to be clarified. And I think that is the first reason why we believe that the project that Global Rights Compliance is carrying out and which is being discussed today is so important. The second reason has to do with the collection, analysis and collation of evidence regarding the conflicts in Ukraine. We believe that this endeavor is hugely important, not least in view of the stalemate that we currently find ourselves in, because we believe that the evidence and the data which is being collected and analyzed hopefully will prove useful at a future time when political dynamics have changed in a way which would allow for a more dynamic policies with regards to the conflict in Ukraine. So we believe that the project we're discussing today also represents a very important investment for the future. The third reason why we believe that this project is extremely important and timely is that the Ukrainian government is currently in the process of developing a number of policies and proposals for legislation, the purpose of which is to contribute to the integration of Ukrainians who live on territory which is currently outside the control of the Ukrainian government, and also to pave the way for such things as transitional justice once a political resolution to the conflict is in sight. Now, in order for those policies and those laws to be able to take shape within the context of a solid legal framework, it is extremely important that the conflicts in Ukraine be analyzed from the point of view of international law, in particular the ambiguities that are raised by the nature of this conflict. So for all those three reasons, in order for international law to be, as it were, abreast with political developments on the ground, in order to collect and collate evidence for future use, and in order to allow the Ukrainian government, or to help the Ukrainian government devise policies and legislation which align with international law. Of all those reasons, it is extremely important that this work be done. So with that, I'd just like to thank all of those who are taking part in today's discussion: legal scholars, practitioners, diplomats, members of civil society, and also, of course, Global Rights Compliance for what we believe is extremely important work. Thank you so much.
Thank you very much, Ambassador. So as you've heard, today's conference is about an ongoing project which is entitled International Law and Defining Russia's Involvement in Crimea and Donbass, sponsored by the Swedish MFA, for whose support we are very grateful. So the project is first and foremost about truth. It has often been said that truth is the first casualty of war, but does it have to be? Of course, from the moment that little green men appeared in Crimea, which later turned out to be Russian soldiers, disinformation has been at the heart of the war in Ukraine. This is hardly a controversial proposition. But does that mean that Ukraine or its international partners and allies have to fall prey to this misinformation, or that truth along with peace and security has to be hidden or worse, even lost? The project premise is that this is not inevitable. Our legal project asks the question, how can international law be harnessed to help promote the truth and help Ukraine protect its sovereignty and territorial integrity? So our project is premised on a simple proposition. The key to fortifying resistance to Russia's involvement in Ukraine is at least in part to be found in international law. Ukraine must respond to warfare with lawfare. At a minimum, Ukraine must seek to demonstrate the legal truth of Russia's involvement in Ukraine, including any violations of international law. Of course, such an approach may seem like an underwhelming response to a war that is now in its 7th year and has already claimed over 13,000 Ukrainian lives. Unfortunately, such criticisms are obviously partly true. Nonetheless, when neither force nor reason have produced answers, lawfare can at least provide a bedrock of legal principle and a record for posterity, which is the bare minimum, we believe, required for accountability and redress. In relation to Crimea, Russia is clearly recognized internationally as an occupying power. However, it is less clear how the legal regime impacts the various rights and duties that fall upon Russia, and also, latterly, those that remain upon Ukraine. These concerns merit a fulsome legal inquiry, including an assessment of the nature of any international humanitarian law and human rights law obligations, and any failure to adhere to such obligations and the legal consequences thereof. As regards Donbass, the government of Ukraine has asserted that Russia occupies this area through its control over separatist forces. Internationally, however, only the Parliamentary Assembly of the Council of Europe has expressly agreed and labelled the area as the temporarily occupied territories. These questions also deserve a fulsome legal analysis. Now, of course, some of these questions will in due course be answered as a consequence of the Ukrainian government's lawfare, including at the International Criminal Court, the ICJ, the European Court of Human Rights, and pursuant to the United Nations Convention on the Law of the Sea. But as the Kremlin is assiduously aware, these institutions are limited by jurisdiction and often delay. Ukraine cannot rely upon only its lawfare at these institutions, however skillful. These mechanisms, however vital, will not provide a comprehensive answer to the many questions of international law that pertain to Russia's involvement in Ukraine. Some of that burden must fall on international lawyers to help Ukraine to collate the facts, clarify the guiding principles, and draw impartial and independent conclusions. Accordingly, for the last 12 months, as you've heard, GRC has been working with the Ukrainian state authorities, multilateral organizations, and civil society to obtain a comprehensive view of facts relevant to Russia's control over Crimea and involvement in Donbass, including their support for the non-state armed groups, with a view to providing very shortly an assessment of some of the most salient international humanitarian law and human rights questions arising from Russia's involvement. We believe this is not mere conflict classification bereft of real purpose. It is a stepping stone to compiling a record based on legal principle that might provide a principled insight into Russia's responsibility, if they have any, for thousands of deaths and the millions of Ukrainian civilians whose lives have been thrown into turmoil by the conflicts. Embedded in international law principles, we believe that such a record will help to guard against misinformation now and in the future. As the ambassador has just spoken about, these principles will also aid Ukraine in its policies, including its ongoing design of deoccupation and transitional justice strategies. And these legal principles will help Ukraine advance its interstate claims at both the national and the global level, and eventually to seek accountability for harms done. And so we have a fascinating conference, I would say, over the next 3 days. It is a critical step in the learning process, the collation of facts, the analysis of the legal principles, and then the drafting of the opinion I've just spoken about. We have 3 mornings to interrogate some of these legal principles with some of the leading domestic experts, as well as the leading international experts. I really believe we have a fantastic group of experts whose contribution, both at the grassroots level and in the courtroom and at the academic level, is second to none. So day 1, we will look at the questions concerning the legal status of Crimea and Donbass, including questions concerning occupation and self-determination, and belligerent obligations arising from humanitarian law and human rights law obligations. Day 2 will focus on both obligations, international humanitarian law and international human rights law obligations, in relation to specific populations such as IDPs, Crimean Tatars, and third parties as a whole. And we will look at gender-based violence and obligations on third states, corporations, humanitarian organizations, and civil society as a whole. And finally, on day 3, we will drill down to focus on specific accountability, looking at various mechanisms, including the ICJ, the European Court of Human Rights, the International Criminal Court, and the UN human rights regime. And we'll look at various jurisdictions, including national and universal, and how they pertain to Ukraine. So exciting days ahead, I would suggest. So before I turn over to our first panel, just some practical stuff. First, there is simultaneous interpretation. I'm sure I'm speaking too fast for it. So do what I haven't done, which is just be aware that what you're saying is being translated. Look for the globe to the bottom right to find the language you prefer. Secondly, please can everyone, aside from the panelists, keep their audio and video off during the duration of the meeting, except when speaking and after being called upon by the moderator. This will help to keep our tech running smoothly. You can raise your hand, look for the button to do that. I'm sure you're all familiar with that. Whether following from Zoom, Facebook, or YouTube, please feel free to comment or question our panelists. We urge you to do that as much as possible and make this as interactive as possible. And so, having spoken too long, over to our first panel, the legal status of Crimea and Donbass, and Professor Ronen.
Hi, so good morning, everybody. Thank you, Wayne, and thank you, Ambassador Tybert. My name is Yaël Ronen, and I'm Professor of International Law. I teach at the Academic Center for Science and Law in Hod HaSharon, and I'm a research fellow at the Minerva Center for Human Rights at the Hebrew University in Jerusalem. And I'm honored and pleased to open this first panel of the conference, which, as Wayne said, focuses on the legal status of Crimea and Donbass. Now, the territories of Crimea and Donbass are characterized differently by different international actors. Crimea is referred to as occupied Ukraine territory, as sovereign Russian territory, or sometimes as disputed territory, which is not a legal term, but one which has appeared in the international discourse. Donbass is referred to as occupied Ukraine territory, as an independent entity, as occupied Russian territory, and not to the exclusion of any of the above, as an area of continuing hostilities. The presentations today will address some of the issues arising from these characterizations. But leaving aside the doctrinal legal questions, disputed status characterization raises a tension between law and politics. On the first hand, the first port of call in order to resolve a territorial dispute requires characterizing it correctly from an international legal perspective. On the other hand, in order to engage effectively with the various actors, in order to protect individuals under their control, it may be more pragmatic, more conducive to speak in terms that are acceptable to those actors. This may mean applying their legal perspective, even if it's not internationally accepted. And this sometimes leads to discourse at different levels. When we listen to the presentations, I invite the audience to consider how this tension plays out, both generally and specifically in the Ukraine cases. Now, as you can see, we have a packed program in this session. Each of our speakers has been requested to speak for no more than 10 minutes so that we have time for discussion. And I do invite the audience to submit questions to the various chat platforms. So let me now introduce our first speaker, Professor Michael Bothe. Michael Bothe is Professor Emeritus of Public Law at Goethe University in Frankfurt am Main, a former president of the International Humanitarian Fact-Finding Commission, and a former president of the German Society for International Law. He served as professor of public international law at the universities of Heidelberg, Hanover, and Frankfurt, and was visiting professor or lecturer at various universities around the world. He served as counsel before the International Court of Justice and the German Federal Constitutional Court, and he's the author of numerous publications on international humanitarian law, international legal questions on the maintenance of international peace and security, international and comparative law. Professor Bothe will speak about the status of the Crimean Peninsula and the law of belligerent occupation. Please, the microphone is yours.
Thank you, Chair. And I'm really grateful for that invitation to join a very important conference on a hot issue of current international relations. Speaking on the status of the Crimea Peninsula under international law, I have, of course, to go into many of the consequences of this status. So I apologize to the following speakers if I have to address issues which they will, I'm sure, address more profoundly. Now, let me start with the facts. There is a de facto control over the Crimea Peninsula, which has changed through a series of events starting February 2014. The question is, has, as a consequence of these events, the de jure control, the sovereignty over the territory, changed as well? If the answer is yes or no, what follows? The fundamental applicable rule is formulated in the Friendly Relations Declaration of the General Assembly of 1970, which constitutes, and it is important to emphasize this, a basic peremptory norm of customary law. The text is, the territory of a state shall not be the object of acquisition by another state resulting from the threat or use of force. No territorial acquisition resulting from that threat or use of force shall be recognized as legal. Starting 27 February 2014, the Russian military presence was increased without Ukrainian consent. The Ukrainian authorities were displaced by the Russian military. New local authorities were established. A referendum declaring the secession of Crimea was held. And on 18 March, a treaty of unification was signed. These developments took place without the consent and against the will of the pre-existing local Ukrainian authorities and of the Ukrainian government. They must therefore be characterized as a use of force. As the referendum was held under the control of new authorities, which had come into power pursuant to this use of force, it cannot be characterized as free and could therefore not constitute a valid exercise of the right to self-determination, even if the population of the Crimea could be considered as a people having such right. By a resolution adopted by an overwhelming majority, the General Assembly in 2014 drew the necessary consequences. It calls upon all states, international organizations, and specialized agencies not to recognize any alteration of the status of the Autonomous Republic of Crimea and the city of Sevastopol on the basis of the above-mentioned referendum. Indeed, only a handful of states have recognized the change. Thus, the attempted territorial change has failed as a matter of law. The Crimea Peninsula has remained Ukrainian territory. This has consequences under the law of state responsibility and concerning the status of the territory, which determines applicable law. The law of state responsibility imposes a duty on all states to cooperate to bring a violation of a peremptory norm of international law to an end, as well as a duty, just mentioned, not to recognize the result of that violation. What does that mean? States must abstain from any act which could be interpreted as recognition. Let us discuss examples. Question of consular protection. A foreign state cannot effectively exercise consular protection vis-à-vis Ukrainian authorities for a national who happens to be on the Crimea Peninsula, as these Ukrainian authorities do no more effectively exercise a control over that territory. But would addressing the Russian authorities who exercise this control for the same purpose constitute a recognition of the territorial change? This is at least the official position of the Foreign Ministry of the Federal Republic of Germany, and I think this is true for many foreign ministries. There are, of course, limits on the principle of non-recognition. In the interest of affected persons, for example, registrations of birth, marriages, and death, they may and must be recognized by third states for the sake of the fate of persons, private persons affected. And that exception has been clearly stated as early as the Namibia advisory opinion of the International Court of Justice. But are negotiations, or is cooperation in the interest of victims of the situation recognition? Not necessarily so, I think. Let me turn to the question of the status. The Russian presence constitutes a non-consented de facto control of a territory by a foreign state. And this is what in international law is called a belligerent occupation. Although there is no more actual fighting, this status continues as long as occupation de facto lasts. This is the result of Article 6 of the Fourth Geneva Convention. Belligerent occupation is a well-defined status under international law. Basic rights of the members of the population and certain interests of the temporarily ousted sovereign are protected. But we have now to address the uncertainty. The practical and legal problems arise from the fact that the Russian Federation denies these consequences. A partial solution of this dilemma, and I think it's necessary to find practical solutions to this dilemma, can only be found in a look on equivalent protections granted by other rules of international law. Let me turn to these equivalent protections. Fundamental rights are guaranteed by the law of occupation in the Hague Regulations and the Fourth Geneva Conventions. These guarantees have a corollary in the extraterritorial application of human rights based on de facto control. This application of human rights law, extraterritorial application of human rights law, is confirmed in the constant jurisprudence of the International Court of Justice and regional human rights courts. Personal freedoms, property are thus protected. That was confirmed by the European Court of Human Rights in relation to the Crimea in a case Ukraine versus Russian Federation. However, loyalty requirements and population transfers, which are prohibited by the law of belligerent occupation, are not prohibited as such by human rights law. Human rights law may nevertheless provide equivalent protections. Important in this respect is what the ICJ held in Ukraine versus Russian Federation, where it recognized that the Tatars and ethnic Ukrainians on the Crimea Peninsula are groups protected by the Convention on the Elimination of Racial Discrimination. The merits of the case are still pending, but the court has clearly said that the convention is applicable to the problem and therefore confirmed the admissibility of the claim. The protection of property brings in the question of protection of investments. The relevant awards are not publicly available, at least not to me, but it appears that arbitral tribunals have applied the Ukrainian-Russian bilateral investment treaty for the protection of Ukrainian investments in the Crimea against expropriation by Russia, apparently on the ground of an extraterritorial application of the BIT based on de facto control, which seems to be an argument similar to the extraterritorial application of human rights. Let me turn to a very difficult question, namely the exploitation of natural resources by the occupying power. This is restricted under the law of occupation, a restriction which does not exist if the transfer were valid. The occupying power is limited to a use of resources according to the principle of usufruct. This means exploitation not exceeding a sustainable yield, for instance, for renewable resources, for renewable biological resources, such as fisheries. while exploitation of non-renewable resources under the regime of occupation is, to say the least, highly problematic. And this applies in particular to oil and gas. Where the resources in question are situated in sea areas, the look for equivalent protections under both regimes requires an analysis of rules on resource management under the law of the sea. In this respect, the Permanent Court of Arbitration, in the framework of the law of the sea dispute settlement system, has accepted jurisdiction, except where its decision requires a determination of the sovereignty over the Crimea. It remains to be seen how far finding equivalent protections is possible without the court pronouncing itself on the question of sovereignty. The exploitation of resources is also a question of the protection of investment, and that brings us back to the question of what happens to licenses given by Ukraine and then expropriated by Russia. So far, an overview which time permits. Let me briefly turn to the procedural issues. Under belligerent occupation, there is no formal remedy. The guardian is the ICRC. Now it's diplomatically difficult for the ICRC to address the Russian government saying you're an occupant, knowing very well that this is the end of the story. I'm not teaching diplomacy to the representatives of the ICRC. I turn to the phenomenon of procedural creativity, which we see nowadays. Human rights complaints under the European Convention of Human Rights, arbitration under investment regimes, and law of the sea dispute settlements are avenues which can be used, and this is a very formal aspect of what has been called lawfare. Let me conclude on the question of uncertainty. Yes, there is uncertainty, but the persons affected in one way or the other may ask lawyers for practical solution, and courts, as I see it, are on the way to provide those solutions. Thank you very much.
Thank you very much. Sorry. Thank you very much, Professor Bothe. We will now move on to our next speaker, Dr. Albert Heinz, who is an associate professor of public international law at the Grotius Center for International Legal Studies at Leiden University, and the director of its Karlshoven-Gieskes Forum on International Humanitarian Law. He is founder of both the Leiden IHL Clinic and the IHL Clinic at Bochum University in Germany. Dr. Heinsch is a member of the German National IHL Committee, and he has held the position of Federal Dissemination Officer for International Humanitarian Law at the German German Red Cross from 2011 to 2014. Previously, he worked as a legal advisor at the Red Cross headquarters in Berlin and as a legal officer in the trial chamber of the ICC. In addition, he has been senior research fellow at Cologne University and a visiting lecturer at Bochum University. Dr. Heinsch will speak about occupation by proxy with a focus on Donbass. Please.
Thanks a lot, Yaël, for the kind introduction, and warm welcome to everyone. And thanks also to the GRC as the organizers for inviting me to talk about this important topic. As Yaël indicated, my topic is occupation by proxy, a focus on Donbass. And I want to divide my presentation into three different sections. I will first start with a short introduction, give a bit of a background why this specific topic is interesting, and also compare it to a presentation I gave 7 years ago at West Point Military Academy, which was not dealing with occupation in the eastern Ukraine, but we were just talking about classification of conflicts. My second part is the main part, and we'll actually look at the fact, do we know and do IHL knows what occupation by proxy is? Do we know this concept? And if yes, how can we deal with it? And I will suggest that we need to approach this on a two-step level or two-step approach. And I will say more about this more in detail during my second part. Last but not least, in my third part, I want to take consequences, find a conclusion for the region of Donbass and see what the application of this legal concept means if we apply it to the facts. Coming now to my introduction. As I said, 7 years ago, almost 7 years ago, I was asked to speak on a similar occasion. We had an expert meeting at West Point, invited by Mike Schmidt, to talk about the situation in the Ukraine. First of all, on the one hand, I'm happy to pick up on that. On the other hand, I'm very sad that I still have to talk about this because it's 7 years later, which brings us to what something Yaël also meant, the discrepancy maybe between the law and the policy. And we have to ask our questions, how can it be that 7 years later, we still have this conflict? But what has changed and why are we now focusing on occupation? In 2014, the conflict at that point was obviously still fresh and the first hostilities had just occurred. The control over respective territory was far from secured. There was another presentation by my colleague Robin Guys who talked about what now Michael Bothe was talking about, the occupation or / annexation of Crimea. Today we have a different situation. It is clear that Ukraine does not have control over its complete territory in the Donbas region anymore. The control is now partly exercised by pro-Russian rebel groups. And this is also the new situation indicated by something, by pure numbers, because some 500,000 people in the self-proclaimed Donetsk People's Republic and the Luhansk People's Republic have been issued with Russian passports since fighting broke out in 2014. So, one preliminary remark. Since the start of the crisis, the characterization of the conflict has been discussed extensively and controversially. I always like to say that it's important to distinguish each situation as such. Even if hostilities are mainly taking place in the territory of one state, that is Ukraine, it is possible that depending on the time and on the location, we reach different conclusions with regard to the characterization of the conflict. So keep in mind, as the ISTY, the Yugoslavia Tribunal in Tadic stated, there's the possibility that in some areas there's an international armed conflict, including a situation of belligerent occupation. And in other areas, there might be a non-international armed conflict, and maybe in still others, there is no armed conflict at all. So focusing on the law of belligerent occupation could, however, with regard to Eastern Ukraine, to the Donbass region, could bring a special advantage for the affected population. Since the Fourth Geneva Convention offers much more protection to civilians in the hand of an occupying party than general international humanitarian law. It's just a vast, bigger amount of rules which are applicable. In addition, it creates a wide range of responsibilities for the occupying power, which is seen as a de facto administrative authority that has only a temporary right, but also has the duty, for example, to maintain public order and safety in accordance with the local laws in force, which includes the prohibition to change the social, democratic, geographical, political, or economic order of the territory. So overall, the characterization of a conflict situation as occupation in the Donbass region would make it more difficult for the occupying power to change the original situation, that's important, and otherwise also would lead to more possible violations of IHL, and therefore the option to prosecute these as war crimes. So that might be also becoming more important in panels which we have later during those 3 days. So occupation by proxy, does it exist? And if yes, how can we deal with it? So this brings us to an important question. Do we have a situation of belligerent occupation in the Donbas region? Michael Bothe, Wayne George already mentioned that international institutions have been quite reluctant, apart from the Council of Europe, with regard to determining whether this is a situation of occupation. First of all, the background of that is clear. We cannot lightly assume that the classical situation of belligerent occupation of one state occupying a part of another state is fulfilled, despite obviously heavy Russian involvement. This is, for example, demonstrated by the UN General Assembly resolution A73 from 2018, which only, in quotation marks I want to say, designated Crimea as under temporary occupation. Both Article 42 of the Hague Regulations, as well as Article 2 of Geneva Convention number 4, seems to presuppose that a regular army of another state is taking over control of the respective territory. However, and that's important always to look at the text of the respective provisions, both regulations don't mention the word state, but talk about the hostile army and partial or total occupation of the territory of a contracting party without indicating the state-like character of the occupier. Given the fact that both the 1907 Hague Regulations and the 1949 Geneva Conventions number 4 were designed for international armed conflicts between states, it is clear that the respective drafters originally did not foresee a so-called occupation by proxy. Nevertheless, it's interesting to note that in contrast to this, Article 1, Paragraph 1 of Additional Protocol 2 speaks of organized armed groups which exercise such control over a part of its territory, so at least acknowledging the possibility of a non-state actor having effective control over a certain region in which the conflict takes place. However, the term occupation is neither mentioned in Common Article 3 of the Geneva Conventions or Additional Protocol 2, which both primarily deal with non-international armed conflicts. But since these rules and provisions, the Hague Regulations and the Geneva Conventions were drafted in 1907 and 1949, it seems to be obvious that we need to transfer these provisions into modern times. And both academics as well as international tribunals have tried to adapt these respective provisions to modern situations of warfare. Possibility, and now in the middle of my second part, the question, how do we deal with this today, this concept of occupation by proxy? Possibility of the existence of an occupation by proxy was actually hinted at, and I call it hinted and not confirmed, by the 1997 ISTY Tadic trial judgment, the 2000 Blaskic trial judgment, as well as the 2003 Natelich trial judgment. Sorry for my pronunciation, I'm really bad at this. The latter's approach being confirmed by the 2013 Pirlich trial judgment. So we have like 4 trial chambers who somehow assumed or dealt with the fact how it is if a third outside state, back then Serbia or Croatia, was having influence on non-state armed actors and dealt with this concept of occupation by proxies. However, we need to take into account that these were trial chambers and was never confirmed on the highest level, the appeals chamber, whether this exists. And that also led to the fact that these trial chambers partly contradicted each other. However, in 1999, the Tadic appeals chamber had opened the door for so-called internationalized armed conflicts in general, using this famous concept of overall control over a non-state armed actor. And this leaves us with the problem of what are the components of this occupation by proxy or indirect occupation. And so I'm now going to suggest the most sensible approach, which has also been confirmed by important actors. And yeah, I know I'm almost running out of the 10 minutes time. I will take another 2 or 3 minutes. I'm very sorry for that. My watch says I have 30 seconds left, but I need a little bit more. I will make a case that the most sensible approach lies in the combination of the approach of the Naletic trial chamber and the Tadic appeals chamber, which requires A, effective control of the non-state actor over the respective territory. So that's the first step. And B, the overall control of the third state over the non-state actor organized armed group. And that should not be confused with each other. This takes into account the explicit wording and majority view with regard to the requirement for establishing belligerent occupation as reflected in Article 42 of the Hague Regulations, which reads, territory is considered occupied when it's actually placed under the authority of the hostile army. The occupation extends only to the territory where such authority has been established and can be exercised. And this has been confirmed, the possibility and the double approach of these two steps has been confirmed by my colleague Niels Melzer in his textbook on IHL, which is published by the ICRC, by the way, where he says effective control does not necessarily have to be exercised directly through the armed forces of the occupying power. Belligerent occupation can also exist when the foreign state exerts overall control over local authorities who in turn exercise the direct governmental control as the de facto state agents on behalf of the occupying power. And he is referring to the respective ISTY jurisprudence. And we also have an indication that even the drafters of the Geneva Conventions in Article 29 thought about this in some way, because they're talking about responsibility for the agents of the occupying power. So that can be a non-state actor. Whether an occupying power exercises effective control depends, on the other hand, on the conflict's party factual ability to assume the de facto governmental functions of an occupying power, and most notable, to ensure public security as well as law and order, and not by its mere willingness to do so. And the ISTY has also elaborated on this, and I will, however, now not go into the detail, leave that maybe for the discussion. Let me now come to the second requirement and then come to a conclusion very quickly. If we come to the second requirement, occupation by proxies, it's a level of control exercised by the third state. I believe that by now the approach of the 1999 ISTY Appeals Chamber for the question of internalization of non-international armed conflicts in the context of the actions of an organized armed groups are to be seen as having overall control, completely being aware that there is a discrepancy and a tension with regard to the jurisprudence of the ICJ, especially when it comes to state responsibility. But this overall control standard has not been only consistent jurisprudence of the ISTY Appeals Chamber, but also has been taken over by other courts and tribunals, including the International Criminal Court. So in that context, I believe the solution is this double approach to have effective control by the non-state actor as an agent and as the representative of the third state, the outside state, exercising overall control. What does this mean for the Donbass region? Very briefly, this could possibly be acknowledged that if we come to the conclusion that pro-Russian rebel groups exercise effective control over the territory in Donbass, and at the same time, Russia would have overall control over these organized armed groups. Is this the case? I want to say most likely, knowing the facts, certain public available facts and assumptions are pointing towards this. However, can I prove this at the moment? I think probably not. And I've written also a long article on this where I'm dealing with this. The problem is always that in the moment, if we don't have a tribunal having the possibilities to do investigations, it always comes to the indication of what do we have there which could prove that there's overall control. And Russia is very often denying its influence or involvement. So we need, it's dependent on these details. So this makes it problematic, but I'm sure there are very many learned colleagues in the room, in the virtual room here, who might also be able to give additional factual background. So this concludes my presentation on the concept of occupation by proxy, which I believe is clear it exists. There are strong signs that we have such a situation in the eastern Ukraine. I thank you for your attention, and I'm happy to answer questions after the fourth colleague has presented. Thanks a lot, Yaël, for giving me a couple of minutes more.
Thank you, Albert. And before we move on to our next participant, let me just remind the speakers of what I always have to remind myself. Don't speak faster, only because if we're running out of time, we do have interpretation here and we do want the audience to be able to follow us. With that in mind, let me introduce our third speaker, Max du Plessis. Max du Plessis is an advocate, senior counsel in South Africa, an adjunct professor at the Nelson Mandela University, an honorary research fellow, University of KwaZulu-Natal in Durban, and a senior research associate at the Institute for Security Studies in Pretoria. Abroad, Dr. du Plessis is an associate tenant at Doughty Street Chambers, London, and an associate fellow at Chatham House. In South Africa, he has appeared in leading cases on international law and human rights law in the Constitutional Court and the Supreme Court of Appeals and the High Courts of South Africa. He has also appeared or consulted before the African Commission on Human Rights and People's Rights, the SADC Tribunal, and the Human Rights Committee. He's acted as advisor to governments and NGOs on questions of an international law. As an international criminal lawyer, Dr. du Plessis has advised states before the ICC and has been working on domestic cases dealing with arrest warrants for senior government in various states in Africa. He has published extensively on international criminal law topics and is a frequent panelist at conferences and events around the world. Dr. du Plessis will discuss the question of lawful secession through self-determination. Please, Max, the floor is yours.
Thank you very much, Yaël. Morning, everybody. I will be speaking on the lawful secession through self-determination. And as I understand it, I'm meant briefly in 10 minutes to sketch the general landscape without necessarily coming to any conclusions, which is just as well. Sir Robert Jennings, a former president of the International Court of Justice, said there's a tendency for international lawyers to keep away from black holes in the system, where the basic assumptions and even the policies of the law have parted from reality. Well, I'd like to perhaps controversially suggest that some states, including Russia, may well wish for the Crimean situation to neatly fall into that black hole. But as I briefly show, there are international law principles that can be drawn together here. And as Wayne Jordas said in his opening remarks, warfare needs to be met by lawfare. And the aim, I think, of our very conference is to avoid black holes. There are examples of successful secessions since 1945 and outside the process of decolonialization, we know that, and which support the existence of the right of a people within a territory that doesn't represent the population of the territory as a whole to secede from that territory. The examples are the Bengali people seceding from Pakistan, the South Sudanese seceding from Sudan, and of course the Albanian people of Kosovo seceding from Serbia in 2008. And the bid by Kosovo for independence statehood, as we all know, ended up at the International Court of Justice. And international lawyers had hoped that the court would set out clearly the legal parameters of secession, but frustratingly, the ICJ's Kosovo's advisory opinion did not address the question of the existence of a right to remedial secession. The ICJ noted that differences existed regarding whether international law provides for such a right of remedial secession, and if so, in what circumstances. But it ducked the overall issue. It ultimately held that it wasn't necessary to resolve those questions in that case. Still, and I'd like to stress the still, two judges in the case did go on to consider whether a right to remedial secession existed in separate opinions. So Judge Concado Trinitado's view was that the government of a state which incurs grave and systematic violations of human rights ceases to represent the people or the population victimized. And he then said that a claim to territorial integrity could no longer be invoked by the rights violating state. Judge Trinidado drew upon the text of Principle 5 of the United Nations Declaration on Friendly Relations to argue that the principle of respect for the territorial integrity of states only applies to those states that are conducting themselves in compliance with the principle of equal rights and self-determinations of peoples, as described in that declaration. And in his separate opinion, Judge Yusuf agreed that the declaration is not exclusively or only there to protect territorial integrity and national unity. According to Judge Yusuf, the right of a people to remedial succession may be invoked in exceptional situations where the people have been denied the right to internal self-determination and there's been a massive violation of human rights. So to step away from that, we can see that openings for secession exist, but that they are very tightly drawn. The circumstances in which remedial secession, in other words, secession exercised in light of a denial of the right to self-determination, or what is sometimes known as external self-determination, may be accepted as a legitimate exercise of the right to self-determination, but is confined to these critically small situations where the people concerned have been denied the right to internal self-determination and have been subject to grave and systematic violations of human rights and persecution. So that allows us to then move to post-Kosovo developments. The failure of the ICJ to provide guidance on the law governing secession and the relative success of Kosovo in its bid for independent statehood. Remember that it was recognized by 117 states thereafter, despite its non-admission to the United Nations. Well, all of that has inevitably resulted in demands for statehood by other entities. The will of a people to exercise self-determination is obviously most clearly expressed in a referendum. And we've seen in recent times how referenda have been used to test public opinion on secession in Scotland, in the Kurdish autonomous region in Iraq, and Catalonian demands for independence from Spain, and more catastrophically in respect to Brexit, but which is a conference all on its own. But all of these attempted secessions have involved historical and cultural groups with a distinct identity living in a separate territory, claiming a right of self-determination. In none of the societies in question, however, has the central government denied internal self-determination or suppressed human rights to such an extent that the right of remedial secession became a possibility. And critically, those referenda have not been compromised by a parallel annexation through the use of force by an outside state. That's why the secession of Crimea from Ukraine in 2014 and its subsequent annexation by Russia is far more complicated. We know the history. Crimea was part of Russia until Khrushchev awarded it in 1954 to Ukraine as a token of friendship. We know that Crimea then became an autonomous region within Ukraine after the dissolution of the USSR, but with a largely Russian population. And we know too that in 2014, when Ukraine broke its ties with Russia and became pro-European, that Russian troops were immediately deployed to and within Crimea. We know as well that a referendum was held in Crimea, in which 95% of the population apparently supported independence from Ukraine and the annexation of Crimea by Russia, which followed shortly thereafter. And the presence of Russian troops, we know, was a factor in this process. And critically, the Security Council, however, was unable to pronounce on the annexation due to the Russian veto, although the General Assembly did condemn it as a territorial violation of the territorial integrity of Ukraine. So, to step away, the decision to secede from Ukraine and to seek incorporation within Russia was the result of a compromised referendum in a territory historically closer to Russia than Ukraine, in which a majority consisting of mainly ethnic Russians voted in favor of secession. On the other hand, the circumstances did not warrant remedial secession, most obviously because there was no grave and systematic violation of human rights and persecution of Russians within the Ukraine. And as we know, the right to remedial secession or external self-determination is extremely limited. You don't have to believe me, you can believe Russia. In the course of the Kosovo proceedings before the ICJ, Russia was very wary at that time, you might remember, of Chechnya's request for independence. And so Russia issued a written statement during the Kosovo proceedings before the ICJ, in which it recorded its position very clearly, and I quote it: "The right to external self-determination," said Russia, "should be limited to truly extreme circumstances, such as an outright armed attack by the parent state, threatening the very existence of the people in question." Those words, of course, should be applied to Russia, not only when it serves its interests, but outside of the Chechen context as well. Perhaps most importantly, to problematize matters further, the Russian military's deployment in Crimea constituted a violation of the territorial integrity of the Ukraine, which was condemned by the General Assembly, and arguably the annexation was invalid for violating a peremptory norm, as Professor Bothe has aptly already described to us. And so now that territory is under what is called temporary occupation, but it remains de jure Ukrainian territory. These complicating factors allow me to conclude. As the Canadian Supreme Court put it in the Quebec secession case, international law contains neither a right of unilateral secession nor the explicit denial of such a right. It's clear, I think, that secession is governed by rules of international law and that these rules guide states in their decision whether to recognize an entity claiming to be a state. But as the debates in this conference attest, the right of self-determination and the principle of territorial integrity, while still both significant principles, are increasingly subject to contestation and qualification. It's the task, I think, of states and international institutions and of ourselves in conferences like these to balance these rights wisely to ensure fairness and stability in the international legal order, and to do so with a very clear recognition that there are forces afoot that are attempting to use their power in ways which ultimately are there to destabilize the international institutions and international rules that are applicable and which make for civilized and peaceful existence together. There can be few examples where that is happening, I think, more forcibly than in the context of Crimea and Russia in the background. Thank you very much.
Thank you very much, Max. And without further delay, let me introduce our fourth speaker, Dr. Sandra Krahenmann. Dr. Krahenmann holds a PhD from the Graduate Institute of International Studies in Geneva, and she teaches at the Geneva Academy of International Humanitarian Law and Human Rights for the Masters in Transitional Justice and Executive Masters in International Humanitarian Law. Dr. Krahenmann's research over recent years focuses on the impact of counterterrorism on human rights law and international humanitarian law, with a particular focus on measures to stem the so-called foreign fighter phenomenon, as well as on the application of human rights during times of armed conflict. And she has written a series of articles on these topics. Dr. Krahenmann will speak about the relationship between counterterrorism and international humanitarian law. Please, the microphone is yours.
Well, thank you very much for the kind introduction. Thank you for the organizers for having organized this conference. So I've prepared a short presentation just also for the ease of audience to follow. So I'm going to share my screen now, which after all of these years, we still have troubles doing. So I'm going to switch a little bit gear now. The previous co-panelists, they have spoken very much about questions of status and conflict qualification and what may be applicable or not. I want to focus more on applicability of law. I think regardless of how we qualify the situation, when we speak about an armed conflict, then, you know, we imply that international humanitarian law applies. And this has indeed been raised by many speakers who spoke about different aspects of international humanitarian law. But what we also see is that in practice, in many of these instances, when there is an armed conflict and international humanitarian law applies, there is a tendency also to resort to another legal regime, the legal regime governing terrorism, which intuitively makes sense because they both address acts of violence, but they address different forms of violence and they're regulated differently. So in my presentation, I want to speak a little bit about how international humanitarian law interacts with the legal regime governing terrorism. And to do that, I'm afraid I need to take a step back and speak first a little bit about what is this actually when we say the international legal regime governing terrorism. How does that legal regime govern or organizes its relationship with armed conflict? And then what does actually also the other side, international humanitarian law, have to say about acts of terrorism in times of an armed conflict? So if we say there is an international legal regime governing terrorism, this is actually not, it's not a unitary regime. You know, it's not like IHL that we can find neatly in the Geneva Conventions and the additional protocols, but it's spread out over various branches of international law. So I want to focus on what I sometimes call the two pillars. On the one hand, we have international treaties that address specific acts of terrorism. And then during the last 20 years, we have seen that the Security Council has actually been very active in developing the regime governing counterterrorism. If we look at the international treaties on a universal level, we have what we would call the sectoral approach, where we have 19 universal treaties that address specific acts of terrorism. So for example, you have a UN convention on the financing of terrorism, you have one on the terrorist bombings and so on. These treaties, they take, they define the act and then they organize the criminal repression of such acts with the idea that perpetrators of terrorism should not be able to find a safe haven somewhere else just because of questions of jurisdiction or lack of extradition. As I've said, there are 19 universal treaties. They all address specific acts of terrorism, which also shows you that we do not have a comprehensive universal treaty. So there's no treaty on acts of terrorism per se. There have been ongoing negotiations for the last 20 years to have such a comprehensive treaty be for the 6th Committee of the General Assembly, but it's not advancing. And there are significant obstacles in trying to find an agreement about how to define terrorism. One of these obstacles is precisely also the question of how that would relate to armed conflicts, including also the acts of national liberation movements. On a regional level, states have been able to overcome this to some extent, where we can find a general treaties on terrorism, and you see 2 examples on your screen, where they have either agreed on a common definition, or some of these treaties also just take the terrorist offenses in the UN conventions and then apply a more general regime to them. As for every other treaty, this of course only applies when states have ratified the treaties. And this is where the Security Council comes in the sense that in the aftermath of 9/11, the Security Council has adopted Resolution 1373 on terrorist financing, where in a nutshell, it took the obligations from the UN Convention on Terrorist Financing and integrated them into the Security Council resolution adopted through Chapter 7, and so made it binding for every state, even those who were not a party to the UN Convention. This has then been repeated on terrorist financing with a more recent resolution, 2462. And another resolution that the Security Council has adopted is 2178, which was adopted against the background of the so-called foreign fighter phenomenon, where the Security Council requested states to make sure that traveling abroad for terrorist purposes is a criminal offense and can be prosecuted as such. So all of these resolutions speak about, financing of terrorism or travel with terrorist purpose, but they do not define terrorism. So it's basically left to the implementing individual member states to define terrorism in their own national legislation, which then of course will depend the scope given to these resolutions in practice. Another pillar of the Security Council framework that I'm not going to talk about too much is the sanctions regime. As you know, we have country-specific sanctions, and then we have the sanctions regime for Daesh and Al-Qaeda and groups associated with them, which is what we commonly call the terrorist sanctions regimes. There are 2 things I want to flag with this regime so this takes a law enforcement approach. An act of terrorism is a crime that needs to be investigated and prosecuted. And it's also a question of individual perpetrators and individual criminal responsibility. There is an open question about whether there can be something such as state terrorism. It's one of the obstacles we also face when we're trying to conceptualize a comprehensive universal treaty. It was also one of the questions that came for the universal treaties, in particular the Convention on Financing of Terrorism, where there was a question that was addressed by the International Court of Justice in the preliminary objections phase in the case between Ukraine and Russia, where there was a question whether the convention also criminalizes a state financing terrorism, or whether then there can be state responsibility for the financing of terrorism as such. So the ICJ has clarified that you can have state responsibility when a state fails to prevent and suppress the financing of terrorism, But under the convention, so not necessarily under general international law, but under the convention, it is not state responsibility for financing of terrorism per se. So that's also like a limitation in terms of the personal scope of these conventions. So I've said how we do not have a comprehensive universal treaty, amongst others, because we cannot agree on how this would relate to armed conflict. And now you may think, well, but how do the sectoral treaties, how do they address this relationship? So I wanted to give you two examples of how they do that. So you have, for example, in the Convention Against Terrorist Financing, which in its definition of what is an act of terrorism, because when you want to criminalize the financing, you need to define terrorism, you can find like a reference to IHL in the sense that it includes deliberate attacks against civilians or harm to civilians, or the people who do not take an active part in hostilities. So that clearly comes from IHL. And it also has a more general safeguarding clause that nothing in this convention will affect rights, obligations, and responsibilities of states and individuals under international law, including international humanitarian law. The Terrorist Bombing Convention has a much more explicit safeguarding clause that we can also find in the Regional Convention of the Council of Europe, where it specifies that the activities of armed forces during an armed conflict, as those terms are understood under international humanitarian law and which are governed by that law, they are not governed by this convention. So if we're trying to think now about the relationship, we can see that the international treaties, they have these safeguarding or exclusion clauses, where there can be a discussion about the scope and how we can operationalize those. But there is a trend to exclude situations of armed conflict governed by IHL. The Security Council in its resolution sometimes make a generic reference that, this needs to be in compliance with IHL, but there is no guidance given on what this actually means and implies and how we can ensure that. National legislation sometimes do, but quite often do not have such exclusion clauses. The problem we then see is when you conflate terrorism with armed conflicts, this can have important humanitarian consequences. And I just want you to flag a few of them. On the one hand, humanitarian organizations have been flagging for a long time that this can potentially criminalize humanitarian activities. So if you deliver humanitarian assistance in an area where you have designated terrorist groups, this may be criminalized, for example, as providing support to such groups. Importantly also, it can criminalize everyday activities of civilians in areas where designated terrorist groups operate or control the territory. So the paying of taxes, for example, can be considered terrorist financing if it is to a group or an organization that is considered terrorist by one of the sides to the armed forces. So civilians quite often also find them squeezed between different parties to the conflict, that they will always consider the other party also be a terrorist actors. We also know that in quite a few armed conflicts, it then also means when the state no longer controls all of its territory and the state considers that there are terrorist entities present in the territory, it will no longer finance critical services in such areas. So for example, teacher salaries. Suddenly nobody will pay a teacher's salary, then who is going to provide education? From a broader policy perspective, it makes also peace negotiations very difficult from both a legal, also from a legal perspective. We all know that you do not negotiate with terrorists, and it's not something that is foreseen for under the terrorist regime. So you may now think, okay, so we have this tension, and it's not just a legal or conceptual tension, but it does have important humanitarian consequences in practice, in particular for the civilian population affected. And how can we resolve that? Well, one way to resolve that is precisely by resorting also to IHL, which is the legal regime that is specifically designed to apply in times of armed conflict. And contrary to what people sometimes assume, IHL actually is equipped and acknowledges that there can be acts of terrorism in times of armed conflict. And this is what I want to conclude with. I think a first important consideration is that the designation of a group or any other party involved in an armed conflict doesn't affect the applicability of IHL. You know, IHL affects when the criteria for conflict qualification, when they are met, as has been explained by the previous panelists. The second aspect is that IHL, it comprehensively prohibits any act that we would ordinarily label as terrorism. Either generically, so, you know, if you take, for example, hostage taking or attacks against civilians, all of this is prohibited under IHL. But there are also specific IHL rules that address terrorism, and you have namely two different kinds of rules. On the one hand, you have a prohibition of terrorism against the civilian population under the control of one of the belligerent parties. And on the other hand, you also have a specific prohibition of attacks or threats of attacks with the primary purpose to spread terror. And then finally, and most importantly, also IHL organizes the repression of such acts as war crimes. And we have some precedents in international criminal law. One of them would be the case of General Galic before the International Criminal Tribunal for the former Yugoslavia, who was convicted for an attack with the primary purpose to spread terror due to the campaign of sniping and shelling that was targeted civilians during the siege of Sarajevo. So I would say that we have seen important humanitarian consequences when you conflate the two regimes. And if you look at how IHL addresses acts of terrorism in times of armed conflict, you don't really gain a lot by conflating the two regimes. And then you need to think about what are the humanitarian consequences that follow from that. Thank you.
Thank you very much, Sandra. Since we have run a little bit out of time, the organizers have decided that we're just going to go through we'll continue during the coffee break, and then we'll go directly on to the second panel, so that we will have a little longer now for the questions and answers session. So we do have questions for all four participants, and let me just in order to let Sandra have a moment to think, I think some of the earlier speakers know what the questions are, that some of the questions are that have been addressed to them. So let me just start with a few of them, and then maybe we'll take a second round. So for Professor Bothe, one question from Mikola Gnatowski is about the reference to the ICRC as the guardian of IHL, which is for diplomatic reasons unable to raise the applicable provisions of IHL with the occupying power, namely Russia. So the question is whether you consider this to be the end of the story, namely that the applicable law cannot be applied, so one would have to look to other applicable rules of international law that offer similar protections. And the question is whether it's this easy to dismiss the applicable legal regime by means, easy for Russia, simply by means of outright refusal to apply it. One question for Dr. Heinsch is, what are the indicators for determining whether a state has overall control over a group? That's a question from Manu Gilab. To Dr. du Plessis, a question on the matter of lawful secession from Charles Shamas. And the question is whether Article 8 of the Fourth Geneva Convention, which states the non-derogability of the rights of protected persons, whether that implicitly precludes the possibility of recognizing a claim of lawful secession based on protected persons' exercise of their right to self-determination in an occupied territory, when that would nullify the applicability of the convention and their rights to its protection. And finally, to Dr. Krahenmann, a question whether the Ukraine was strategically right in invoking the Terrorism Financing Convention as the legal basis for the ICJ proceedings, considering that there is an ongoing armed conflict in eastern Ukraine. Russia argues that IHL and terrorism suppression regimes are mutually exclusive. So what is your view on this? So if I could ask each of the speakers to respond to the question, and maybe to the other speakers if there's something that you'd like to raise, and then hopefully we will have time for another round of questions. Thank you. And can I just suggest for the sake of good order, let's start with Professor Bothe.
Well, thank you. And I put the case in my intervention, my contribution, just provoking that very question which has been asked. It's bad diplomacy if one actor tells the other, you're a bad guy, therefore you have to behave. The ICRC is more sophisticated than that. Now, it's for sure that if the ICRC would just plead the law of belligerent occupation, it could not get very far in the negotiations with Russia, negotiations concerning the fate of members of the population, because that is the essential point here. Now, there is what the ICRC has called, and what is now an accepted term in international law, the right of initiative of the ICRC. And you do not find that clearly in the Geneva Conventions, but it is, I think, and many agree, well established under customary law. And that goes far beyond situations to which international humanitarian law is technically applicable. It has been used in the early days of the Cold War for visits of political prisoners. Whether the prisoners were political could have been left open, but the basic idea was that the prisoners, persons present in some jails around the world and mainly in Europe, had something to do with the political situation. That was a very effective and useful initiative of the ICRC. And this is a basis, this right of initiative, which could be used by the ICRC without claiming the law of belligerent occupation is applicable. But it would provide what I have called equivalent protections. I think this is practically important. So in this way, the ICRC is a kind of de facto guardian without claiming to be a de jure guardian of international humanitarian law. Thank you.
Thank you. Let's move on to the second question to Albert Heinz.
Yes, thanks a lot. Thanks, Emanuela, for the question about the indicators for determining whether a state has overall control over a group. I want to say it's nice to see you again, but I don't see you because last time we saw each other was at an IHL Clinic exchange conference in Rome. So hello, good to see you. But coming to this question, and I'm happy that you asked this question because I had it in my presentation, but cut it out because due to time limits and I didn't want to offend anyone. So quoting from the ICTY jurisprudence, the overall control test in the most general term says that it must be proved that the state wields overall control over the group, not only by equipping and financing the group. So that means just paying the group or giving weapons, etc., is not enough, but also by coordinating or helping in the general planning of its military activity. So the key is the general planning of the military activity that would require that certain Russian representatives, government officials, military commanders are in connection with the rebel groups in the region and are giving general planning, but, and that is the second part of the quote, however, it's not necessary that in addition, the state should also issue either to the head or to members of the group instructions for the commission of specific acts contrary to international law. So what is not necessary is to give specific details on what the rebel groups are supposed to do, saying like you have to blow up that building or attack the enemy at that time on that day with these kinds of weapons. So that would be what the ICJ would require for effective control. So in the end, the ISTY is having like a broader approach, which, as I said, I believe has been accepted by the international community and by international courts and tribunals when we talk about the internationalization of NIACs. So, and that brings me, and I'm looking at Yaël, whether I have a question to time to answer the question by Ariq on the question whether this makes now a difference between whether it's just an internationalized NIAC or an occupation by proxy, because in some ways the standard seems to be the same. Can I say 2 sentences on this?
Yes, go ahead, and then we'll let the others, we'll add other questions later.
So the question was, how do you think about the relationship between the internationalization of NIAC and the occupation by proxy? If we can simply apply the overall control test to the problem of occupation by proxy, that is the required relationship between the intervening state and the non-state armed group, which control the concerned territory, the issue is not so unique. And there's much more, and I don't go in all to the details. I want to say it's still unique because the difference is that the non-state armed actor needs to have effective control over the territory. So it needs to have actually the access and the possibility to exercise normal administrative and governmental functions. And that's something which some people are already questioning, whether actually non-state armed actors are actually able to do that in the same way as government forces. And so in that regard, what I said at the beginning and what I'm emphasizing is this two-step approach makes it so unique because it raises in the end the requirement on one level, namely the control over the territory to the effective control, while the influence of the third state is only overall control. So the combination makes it unique, and it also makes it unique in a way that obviously once we say law of belligerent occupation GC4 is applicable, we have a much more elaborate set of rules applicable to the situation, which, as we will learn in the coming days, might also give us access to much more possible violations of the occupying force. So happy to discuss this maybe bilaterally, but I don't want to take more time from my other colleagues. So thanks a lot for the questions.
Thank you, Robert. Just before we move on to Max, which is on my screen, your picture is completely frozen. I hope you're with us. Max? Oh, okay, you're there. Okay.
I'm here.
So let me just before I let you answer the question. There was a question from Charles Shamus about the relationship between the right about a lawful secession and the non-derogability of the Geneva Convention. Let me just add another question that has arisen: is what role, if any, does the Security Council play in the context of secession and self-determination? For example, would it have made a difference if the Security Council had condemned Russia's annexation of Crimea? And also, specifically with regard to the Ukraine, when you discuss the integrity of the referendum and the preconditions for remedial secession, are you by implication saying that you do consider the population of Crimea to be a people?
Thank you very much. And thank you for the question, Charles. It's an interesting one. Certainly, your reference to Article 8 of the Geneva Conventions. And indeed, it's true. I mean, protected persons may in no circumstances renounce in part or in entirety the rights that are secured to them by the present convention. Well, that's so, but quite aside from those rights, of course, there is the inalienable right, the fundamental right to self-determination that exists for people, and which is not in any manner or shape or form undermined by the fact that they have been occupied. So an occupying power does not by occupation get to override the rights of those that they occupy, not least of all their most fundamental rights to self-determination. And so I would agree with you that implicitly that would preclude the possibility of trying to certainly denounce anybody's rights to continue to claim their rights to self-determination simply because they've been occupied. The other question that I think Yaël has asked is around the role of the Security Council and if it plays any role in the context of secession and self-determination. As I said in my talk, one of the complicating factors in Crimea's succession is the argument that Russia's deployment of military in Crimea constituted a violation of territorial integrity of the Ukraine. And that's so certainly within the meaning of the concept as defined by the ICJ in its Kosovo opinion. So given that Russia's intervention was forcible, arguably the annexation itself was invalid for violation of the peremptory norm. And we know that no right may arise from a wrong. And it follows that the title was acquired by the use of force would then also no longer be recognized. And we've seen that, and interestingly, we've seen that very forcibly through the Security Council's non-recognition of Israel's purported annexation of the Golan Heights and East Jerusalem. And we've seen it as well in the General Assembly's resolution calling upon states not to recognize a change of status on the territory of Crimea following the annexation by Russia. But there's obviously a difference, which is that unlike Israel's annexation of East Jerusalem and the Golan Heights, that had been condemned as illegal by the Security Council. But the annexation of Crimea has been condemned only by the General Assembly, which arguably weakens the case against Russia. But we know why it's not been condemned by the Security Council, and that's because of Russia's ability to use its powers on the Security Council. And to me, that is critically important because it demonstrates in this particular context the very worrying ability of a permanent member of the Security Council being enabled to both assert an act of annexation on the part of a territory of another state, and then to protect itself from any condemnation thereof. And I think that has to be resisted, for else we would have a very dangerous precedent allowing President Putin to continue turning his Soviet Union fondness into action. And I think we've got to recognize that this is a resistance that's required because of multiple failures of the work of the Security Council. It's not only in respect of the Crimea context, it's in respect of what we now know will be the impossibility of getting the Security Council to make any interventions of any assistance in respect of what's happened in Belarus, again, because Russia would be able to veto. And we've seen in multiple ways that the Security Council is an institution which has the power to issue very forceful condemnations and which would then otherwise have had the effects, as we've seen in respect of Israel, not being permitted to get away with the annexation of what has happened in East Jerusalem. Yet in other contexts, the Security Council being abused and its forceful power not being used in a manner which it should be. So I think this demonstrates for me the purposes for debate of precisely where the Security Council's role should be in this context. Should we not actually be moving all our focus towards the General Assembly? And should the General Assembly not be the better means by which we more democratically recognize the means by which the international community accepts and recognizes these types of events? Then there was a final question about whether the peoples can properly be recognized as a people within the Crimea as Russian. I think there's a lot been written about that. I think there are numbers of debates about it. I don't think we have the time to go into it, but certainly it is one of the points, because unless they can be shown to be a people in an homogeneous fashion for purposes of self-determination, that in and of itself would be something to consider. It's certainly a legal element for purposes of the debates around self-determination, and it also requires, I think, a proper analysis.
Yes. Okay. Just before we move on to the questions to Sandra, just a follow-up on part of a follow-up on the last issue of the Security Council lack of hypothetical resolution. Marco Longobardo asked if, in light of the Chagos opinion and previous ICJ opinions, shouldn't we consider the General Assembly to be the competent UN organ to deal with self-determination rather than the Security Council?
I would emphatically agree.
Okay, that was a quick one. Okay, so let's move on to Sandra with, again, the question related to the reliance on the Terrorism Financing Convention as the legal basis for the ICJ proceedings. And let me just add another question, which is the anti-terrorism conventions deal with international terrorism. And I wonder how your analysis would work if we look at the situation as a non-international armed conflict or situation. Would that simply exclude the issue of terrorism altogether? Or would there still be an issue of a relationship between anti-terrorism or counter-terrorism law and IHL? Please, Sandra.
Well, thank you for the question, Irina. It's an interesting one, but I think we need to take a step back, because we have been speaking a lot about lawfare now, and that there needs to be a role for the law in addressing and dealing with that kind of situations. And then you can do what we are doing here now, where you interpret and you look at what does the law actually say. But then on the other hand, and that's what Ukraine has been doing, you also try a way to implement the law. And of course, one of the obvious ways to go about this is by bringing a case before the International Court of Justice. But then when you do that, you're also constrained by the inherent limitations that we still have in the international legal system when it comes to the judicial resolution of disputes, where you don't have an option of to say which is the best case under which convention, and then we can go to the ICJ, because you need to find a basis for jurisdiction for the ICJ, no? And then I think you look at what is available, and one of the conventions that was available was the Terrorist Financing Convention, and then also third, the Convention on the Elimination of Racial Discrimination. So it's one of the possibilities that you have. You don't have the possibility in the Geneva Conventions or the additional protocols. They do not have a compromissory clause. So even if you could think, well, this may be the strategically better way, it's not an option that you have, because then you will simply have no jurisdiction. So I think you need to look at what is available and how can you use that for your case. For the second aspect on the mutual exclusiveness, I don't think that any regime is completely mutually exclusive and there's no separate regime, no? They all interact with each other. I think my main point is that there is an overlap between these two legal regimes, and then that overlap needs to be harmonized in a way so that we do not end up undermining one regime over the other. And I think that's particularly the case for international humanitarian law, with its primary purpose of protecting civilians, because we have seen during the last decade how the conflation between the two regimes leads to an increased suffering of the civilian population through various ways and mechanisms. For your question about the international element, I don't think I would link that to the conflict qualification per se, because also, as you know, international humanitarian law has a very particular notion of conflict qualification. Now we have two things. We have international armed conflicts and we have non-international armed conflicts, and they do not necessarily fit with how we look at a conflict. Like colloquially, most non-international armed conflicts today, they have an important international element in one way or the other, with either foreign states intervening with the consent. So it remains a non-international armed conflicts. You can have the use of proxy forces. So I would not tie the international element in the terrorist conventions to the conflict qualification, because I think conflict qualification in IHL operates in such a specific way and for such a specific purpose, while the international element for the terrorist convention operates in a different way and for a different purpose, if that makes sense.
Makes sense to me. I hope to the rest of the audience as well. Okay, so thank you all very much. And please join me in thanking all our speakers for excellent presentations, our audience for super interesting questions and good answers as well. And thank you again to the organizers. So let's take the break.